Hold up, hold up, hold up. What happens when a defendant decides to turn a routine court hearing into an absolute circus? You're about to witness Jeff Bloom. Yes, the Jeff Bloom. Go completely off the rails in front of a judge who's had enough. We've got accusations of missing evidence, claims of ex parte communications, and defendant who literally gets kicked out of his own hearing. This isn't just courtroom drama. This is a masterclass in how not to represent yourself. And trust me, when the judge starts saying goodbye 3 times, you know things have gone sideways. Buckle up, because what starts as a simple assault and battery case, scheduling turns into one of the most unhinged courtroom moments we've ever seen. Let's dive in.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, who is present.
What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up.
Got it.
But I can make the August one work, and I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
Okay, pause. Did you catch that? The judge literally just tried to get Bloom out of the courtroom before he could say anything. This judge knows what's coming. She's dealt with this guy before, multiple times apparently, and she's trying to prevent another disaster. But here's the thing about self-represented litigants who think they know the law. They never take the hint. Watch what happens next, because Bloom is about to open Pandora's box, and once he starts, there's no stopping this train wreck. The suspended license comment? That's just the appetizer to this feast of chaos.
I was going to try to get you. I was going to try to get you out of the room. Bloom. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least I'm not driving with a suspended license.
I have no comment.
Okay. 2 times now I've let it go. Remember?
Let what go?
I said enjoy the day, enjoy your horse, all that. So I let it go. The time before that I let it go. But Your Honor, today I need to put something on the record. This is very serious.
Put something on the record all the time. Go ahead.
Okay. No, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given the hospital report, any photos, any. There's a lot missing from discovery still. Remember, since October, we've.
No, I remember you mentioning it, but hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
Hold. This is why. Mr. Bernstein.
Which discovery referencing, Jeff? Hospital report that Deputy Soyring says there was a hospital report. There was. I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report.
Mr. Bloom.
Okay, I'll let it go.
Because you keep asking me questions you know I can't necessarily answer.
The real stuff. Oh boy, here we go. This is where Bloom completely loses the plot. He's been fighting for discovery that apparently doesn't even exist. The attorney just confirmed there was never a hospital report. But does that stop our guy Jeff? Absolutely not. Now he's pivoting to transcripts from 3 months ago that he claims he never received. But here's the kicker, and this is important for anyone watching who thinks they can handle their own legal matters. You need to make written requests for court transcripts. You can't just verbally ask and expect them to magically appear. His attorney is literally standing there trying to help him, but Bloom is too deep in his own conspiracy theories to listen. This is about to get so much worse.
Okay, let me get on with the real stuff.
Oh, okay.
For transcripts.
No,
I still haven't received the transcripts.
Of what?
3-6. Remember I asked for the transcripts from 3-6? I still haven't received transcripts from 3-6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, you have an attorney, tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistance and you have assistance.
I don't have assistants. I have individuals that I work for that are professionals. So I don't know what you have, but I don't
professional
have,
real.
but go ahead.
I can clarify what Jeff's talking about. I ordered an audio recording of that hearing, and someone in my office kind of like, we did a transcription of it for Jeff, but I think what he wants me to request is an actual transcript, and I just didn't.
Well, and so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received written requests for that, then that won't happen. So,
thank you. Well,
ladies and gentlemen, this is the moment where everything falls apart. Bloom just pulled out what looks like prepared notes and is about to accuse the judge of bias based on statements from completely different cases. He's literally reading from dates that predate his current assault and battery case. October 4th, September 13th. This case didn't even start until October 18th. He's mixing up multiple cases, multiple hearings, and now he's about to accuse a judge of believing everything law enforcement says. Pro tip: never, and I mean never, attack a judge's integrity without rock-solid evidence. This is legal suicide happening in real time. Folks.
Well, I ain't going to go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy said.
Hold on a second. What are you reading to me right
now? Something that I want to state on record, Your Honor.
No, but what you're obviously stating what somebody else said. I'm just trying to figure out where it's coming.
You said.
On the 24th of.
No, on 10-4 of 22.
In this case?
No. You stated that you believe everything a Washtenaw County Sheriff's Deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authority of authenticity and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10-4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be in regard to your other matter because this didn't start. No, stop. This case didn't start until 10/18. So if you're referring to a record from another case,
then I'm past that.
Then you're past what?
I'm past the other case.
Oh no, he's citing canons. This is where Bloom goes full sovereign citizen mode. He's literally reading judicial conduct rules to accuse the judge of ex parte communications. That's secret. Illegal conversations with one party without the other present. But here's what's insane. The judge actually disclosed a communication about his dental work to all parties, which is exactly what she's supposed to do. Bloom is taking transparency and trying to twist it into corruption. You can hear the judge's patience evaporating in real time. She's given him chance after chance. But accusing a judge of violating judicial canons without any real evidence? That's a nuclear option. And he just pushed the button.
Here we go. This is this case. Canon 2, Canon 2A, Canon 3, which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court. It is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you because what are you talking about?
I'm talking about the transcripts from 3/6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
No, that was regarding your dental?
Yes.
Yeah,
that was a motion we filed.
No, but that has nothing to do with the case.
But I mentioned that on
Mr. Bloom. No, Mr. Bloom, because if you're going to, you don't want to hear, I don't. because what you're saying is incorrect.
Okay.
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
There were other matters you did the same thing, Your Honor.
And there it is. Goodbye, goodbye, goodbye. The triple goodbye. When a judge says goodbye 3 times, you're not just dismissed, you're banished. This is the courtroom equivalent of being thrown out of a bar at 2 a.m. Bloom pushed every single button, ignored every warning sign, and turned what should have been a 5-minute scheduling hearing into an absolute disaster. His own attorney is probably dying inside right now. The prosecution doesn't even need to say a word. Bloom just handed them everything they need on a silver platter. This is why they say a lawyer who represents himself has a fool for a client.
I'm not
Goodbye. Goodbye. Goodbye, Mr. Bloom. Goodbye. Thank you. Have a great day. Take care.
We'll contact the senior commission, sir.
Asterisk. So let's break down what just happened here, because this is a masterclass in what not to do in court. Jeff Bloom came in with an assault and battery case that should have been a simple scheduling matter. Instead, he demanded discovery that doesn't exist, confused multiple cases, accused a judge of bias without evidence, cited judicial canons he doesn't understand, and got himself literally thrown out his own hearing. The judge tried to help him multiple times. She even tried to get him out before he could damage his case further. But some people just can't help themselves. Here's the thing. The legal system has rules for a reason. You can't just walk into court with a bunch of conspiracy theories and expect to win. This judge showed incredible patience. But when you start attacking the integrity of court itself, game over. Bloom's case is now heading to a settlement conference in August and jury selection right after. And you can bet this outburst will be remembered. If you found this courtroom breakdown as jaw-dropping as we did, smash that like button right now. Drop a comment below. Do you think Bloom had any valid points, or did he completely sabotage his own case? And if you want to see more insane courtroom moments like this, hit that subscribe button and ring the notification bell so you never miss our next breakdown. We'll see you in the next one. And remember, if you ever end up in court, maybe don't do what Jeff Bloom did. Peace out.